I heard my aunt's voice crack when the notary read the part she never saw coming. The signatures she bragged about, the witnesses she paraded, all of it started to fold the minute my grandmother's own words entered the room. We'd already spent weeks in a tug-of-war over grief and money, but that was the second I knew the ground had finally shifted under her feet. If you clicked because the title promised a family member tried to cut me out, and I flipped the inheritance back using one clause, you're in the right place. This is that story. I'm the woman who runs the channel after her lies, and today I'm walking you through the exact steps I took when my aunt tried to erase me from a $450,000 estate. You'll hear the dates, the documents, the courtroom moments, and the shock that rolled through our family. I'll never ask you to take my word for it when receipts exist. My name is Erin Maddox. I'm 34, based in Columbus, Ohio, but the drama took me to a glass and brick law office in Worthington, a probate courtroom on High Street, and back to a dining room where my grandmother once taught me to balance a checkbook. The her in After Her Lies was my Aunt Lydia, my mum's younger sister, who moved into my grandmother Ruth's house last fall to help. And by help I mean take charge of every piece of paper that came through the door. Grandma Ruth passed on June 2nd, 2025. The first official meeting at the notary's office was scheduled for June 10. The stakes: a paid-off house appraised at $280,000, a brokerage account that held $170,000, and a checking account worth about $32,000 that needed to be split according to a will we hadn't yet seen. I'd been told there was a trust. I knew there was a 2019 will. But on June 10th, I learned about a March 3, 2025 codicil that tried to hand everything to Lydia and cut me out entirely. The codicil included the words "in gratitude for her care." There was also a 2023 durable power of attorney naming Lydia A. paper that dies with the principal but looks impressive to anyone who doesn't know the difference. At the funeral, 3 days after Grandma's death, Lydia leaned on the back of a pew and announced to anyone in earshot that I didn't need anything because I had my little YouTube. She did it right after the hymn, when people were still wiping their faces. People turned. I felt my cheeks burn. She'd already changed the locks for safety, and she'd told the bank not to speak to me because Erin's emotional. If humiliation had an orange carpet, she rolled it out and invited me to step onto it in heels that didn't fit. It wasn't just my pride. If she got away with it, I'd lose the house where my mum grew up, I'd lose the last of my grandmother's savings, and I'd lose the plan my grandmother had whispered to me 2 months earlier over tea, that she wanted me to have the house because you'll keep it full. June 10th started like every bad meeting in a lifetime of bad meetings. Coffee, a timer in my head, and a receptionist's practice smile. The notary, Mr. Sanchez, was neutral to the point of disappearing. He read, "Original will, dated July 15th, 2019, leave the house to Erin, the rest equal between Erin and Lydia." Then the codicil, dated March 3rd, 2025, revoked the gift of the house to Erin, instead leave the entire residue to Lydia, with gratitude for care and financial support. 2 witnesses signed. A notary stamp that, at first glance, looked fine. Lydia sat back with her arms crossed and her face wearing triumph like a new watch. 2 things slammed into me. 1, my grandmother had said, "Keep it full." 2, in April, she had told me on my porch that she'd put a green binder in her bedroom closet for when Lydia gets pushy. I had the message saved, 12 minutes, 49 seconds, dated April 17th, 2025, 8:12 p.m. She described where the binder sat and said there was a clause in the trust she needed me to read if anything looked off after her death. The problem was I wasn't allowed in the house. Lydia had changed the locks, and when I'd asked for my grandmother's recipe cards, she said, "Those aren't a legal priority." I left the notary's office with a copy of the will and codicil and a knot behind my sternum. I had two immediate obstacles. First, money. Anyone who's hired a probate litigator knows retainers start at numbers like 7,500 or 10,000, and that's before depositions and handwriting experts. Second, the no contest clause. The 2019 will included language saying that if any beneficiary contested the will without probable cause, they'd forfeit their share. If the March codicil held, I had nothing to lose. But if the codicil fell and I had contested too aggressively, I risked losing the house even under the 2019 plan. It's like standing on two stones in a river and having to jump without knowing which one is loose, humiliation scaled. At the repast, Lydia told my mother's old friends that it was sad I was so money-obsessed and that I couldn't let go. She mentioned my channel sarcastically. "After her lies? Honey, try after her rent is due." I smiled the way you smile when you want to scream, but you're holding a paper plate of casserole and a child is watching you. Meanwhile, the bank spoke to me in scripts. "We can't release information until the personal representative is appointed." Lydia filed to be that person the day after the funeral. She told the probate clerk that she had the funds to maintain the property and that the heirs weren't in agreement. What she meant was that I refused to sign a form she pushed at me during the repast that said consent to independent administration. They were words on a page, and she wanted my signature alongside the potato salad. At night, I listened to my grandmother's voice on my phone. She said, "Green binder, closet, clause 8, and don't let anyone tell you you're being dramatic." The green binder was my first leverage. I also remembered something else. In 2019, my grandmother and I had sat at her kitchen table while she logged into her brokerage account. She said she set a transfer on death designation. "It's simpler," she told me. "It bypasses all the mess." She wrote my name on a post-it, and we took a picture together because it felt like a rite of passage. If the TOD designation was still valid, that 170,000 would pass directly to me outside probate. If it had been changed, there would be a record. I couldn't afford a full-scope attorney. What I could do was file a caveat to pause the appointment of Lydia as personal representative and buy time. I went to the probate clerk's window with my own petition and a stack of exhibits. The will copy, the codicil copy, my grandmother's April 17th audio printed out in transcript form with a certified date stamp from my phone provider, and a request for a short continuance because the green binder could contain dispositive information. The clerk didn't care about my story. She cared about whether my petition had a case number and a filing fee. I paid $102 on my debit card and walked out with a hearing date, July 29th, 2025. July 29th felt like a lifetime away, but bureaucracy is its own meteorology. Meanwhile, I needed access to the house to find the binder. The only lawful way was through a court order or through the bank, because the key to my grandmother's safe deposit box might be in that closet. The afternoon after the notary meeting, I drove to the house. The new locks mocked me like clip art. I took photos from the sidewalk. Through the front window, I could see the green binder sitting on the top shelf of the closet, angled like a tilted book in a library display, because my grandmother had a way of pointing things with quiet tenderness. I made a plan with 3 steps. Step 1, service. People act differently when they're handed a stopwatch. I served Lydia with my caveat and a notice of the July hearing. My server reported she smirked and said, "Can't wait to see you lose." Step 2. Records. I contacted the brokerage and asked whether a TOD designation existed and whether it had been changed. The answer, due to privacy and because the account holder had passed, they would only release that information to the personal representative, Lydia, if she was appointed, or me if I won. But the phone rep did say the magic words. There is a beneficiary designation on file. Step 3. Witnesses. The codicil had 2 names under it, a neighbour from down the block and a man I didn't recognise. I found the neighbour, Mr. Halverson, on his porch with his dog. He told me he signed because Lydia asked him to and Grandma didn't say much. But he was uneasy because the other witness had left the room at one point to take a call. He also told me that the notary stamp looked old. He meant worn, but the word stuck in my head. Old could also mean expired. I went to the UPS store on Henderson Road, where I knew my grandmother had her mail held during vacations. The manager remembered her. He told me that in February, Lydia brought my grandmother in to notarize something, but they declined. Her hand was shaking and she didn't seem oriented, he said. He logged it. January 29th, 2025, 10:43 a.m. Declined for competency concerns. I asked for a letter. He wrote one on their letterhead stating they refused to notarize documents for Ruth Maddox on that date due to concerns about capacity and that they suggested the family obtain a medical evaluation. Another piece of the wall. By then, Lydia had hired a lawyer. I received a sharp letter from a firm on Broad Street accusing me of maligning my aunt and of furthering my online brand at the estate's expense. They threatened to seek sanctions if I pursued a will contest. They wrote the words "no contest clause" 3 times, as if the repetition could turn law into magic. What they didn't know was that the green binder had been described to me, and so had a clause number. My grandmother may not have known the right legal words, but she knew a paper can be a door. I filed a motion for temporary access to the residence to retrieve a binder marked Estate Read Me. I attached the photo I'd taken from the window with a ruler against the glass to show scale. The judge's assistant called and asked me if I was a lawyer. I said no. She told me pro se litigants rarely succeed with these. I hung up and recorded a video for my channel, crying off camera after I turned the lights off. Then I remembered the safe deposit box. The house was one door, the bank was another. I hunted through my grandmother's sewing machine cabinet, which Lydia had left in the garage. In a velvet ring box, I found a small brass key with a tag, Huntington SDB 304. I felt my heart bang against my ribs. Safe deposit boxes can be opened after death with a court order or by a person listed on the contract. I wasn't listed, but the bank could open for the limited purpose of locating a will and burial plot info. The manager agreed to a limited opening on June 24th if both family members named in the will, Lydia and me, attended with the notary Mr. Sanchez. We stood side by side in a cold, grey room while the bank manager turned a key that echoed. Inside the box sat a modest, clear folder and a pack of my grandmother's stamps. In the folder, a letter to me in Grandma's looping hand, dated December 28, 2024, and a laminated copy of her 2019 revocable trust with a 2021 restatement and a tab that said Clause 12C. The letter said, "If Lydia gets pushy, read 12C and call Mr. Parker at the brokerage. Remember that your love is not a bargaining chip." There was also a thumb drive labelled Binder Video. We went back upstairs and the manager copied the documents. Lydia was fuming. She hissed that I was stealing. The manager told her the process was routine. I held the trust like a lifeline. Clause 12. C. Read, caregiver disqualification. If, within 12 months prior to my death, any beneficiary provides paid caregiving services or receives compensation for caregiving or holds a power of attorney and is a substantial beneficiary under any amendment executed during such period, such amendment is presumed the product of undue influence and is void. The prior terms shall control. My jaw went slack. Lydia had been paid $18 per hour through a county caregiving program from September 1st, 2024 through May 2025. She had the 2023 power of attorney. The codicil was executed March 3rd, 2025. The trust didn't directly govern the will, but the trust terms controlled trust assets, including the house if it was titled properly. And this clause told a story. If Lydia used her position to change gifts, those changes were presumed void. It's one thing to feel like you have a weapon. It's another to know if it's loaded. I drove home, plugged in the thumb drive, and watched my grandmother on my laptop. The video showed her sitting at her kitchen table wearing her blue cardigan. She said, "It's December 28th, 2024, and I'm reading this for Erin because I am forgetful these days, but I am not confused. The house stays in the trust. Erin gets the house, Lydia gets money, and I love her. But she likes to argue and she is taking care of me, and I know what that looks like to people." Clause 12C is there to prevent that. If someone shows you a paper after March, check the dates. I'm asking you to be brave. I paused at 3:13 p.m. when she said my name and wiped my face with my sleeve. The metadata matched the date. It wasn't just grief that broke me. It was my grandmother speaking like she knew she had to leave me a path through a storm. And then I saw the clause nobody expected. On the last page of the trust restatement, under the signature, sat a self-proving affidavit. It wasn't only for wills. My grandmother's lawyer had added it to the trust for good measure. 2 witnesses from her church had signed, and a notary with a commission good through 2027 had stamped it. My grandmother had layered her intentions like floors. The house had been deeded into the trust in 2019 via a quitclaim deed. That meant the house wasn't a probate asset. The 2019 will's gift of the house to me was a belt and suspenders move. The March 3 codicil that revoked the will's gift didn't reach the trust's ownership. Lydia's codicil could only claw what the will controlled, the residue, after the trust did its work. The house, the biggest piece of that 450,000 pie, was out of her reach if the trust held. Lydia either didn't know or didn't care. She might have assumed the will decides everything, because a lot of people do. The trust restatement also included a specific instruction. On death, the successor trustee me shall record a certification of trust and an affidavit of death to transfer trustee status and confirm title. It named me, not Lydia, as successor trustee. I still had to get that binder from the house to corroborate the video and to make sure there wasn't some later trust amendment. Lydia had changed the locks. While I waited for the July 29th hearing, I did the unglamorous work. I pulled my grandmother's caregiving payment records from the county portal and printed the time logs. September through May, at least 20 hours a week, line after line, 18 per hour, total 22,614 paid. I pulled the dates of Lydia's power of attorney and matched them against doctor appointments and bank withdrawals. I called Mr. Halverson, the neighbour, and he agreed to sign an affidavit about the day he witnessed the codicil. He said Lydia called him the night before and asked him to be on standby, which suggested a plan rather than a spontaneous act. I requested notary commission status from the Secretary of State. The notary whose seal appeared on the March 3rd codicil had a commission that expired March 1st, 2025. The stamp used on March 3 was expired by 2 days. I read the statute 3 times to be sure. Sure enough, in our state, a notary's act after expiration is invalid. It's not a technicality, it's a speed limit sign. That's when Lydia flipped from smug to loud. She showed up in the comments under a video where I narrated the difference between wills and trusts in general terms without naming her. She wrote that I was exploiting my grandmother's death for content. I took the video down. I didn't want my fight to be content. I wanted my grandmother's voice to be the loudest thing in the room. I saved the comments anyway. You'd be surprised how often offhand online remarks become exhibits. A week before the hearing, I received an email from the brokerage. They said they'd received a request from Lydia to change the TOD beneficiary designation in March, but that the request had been rejected because the form wasn't properly signed by the account owner. They attached a redacted copy that showed a shaky signature and a notary stamp with the same expired commission. Rejection date, March 12, 2025. That meant the 2019 designation naming me as beneficiary remained effective. The money didn't even belong to the estate. It was mine by contract. I cried again, louder. I also got angry because the bank had frozen the account out of caution due to the dispute, and I had to prove, step by step, that caution should favour the person the law favoured. On July 29th, I walked into the probate courtroom in a navy dress and flats with a tote bag that felt like a portable library. The courtroom had the energy of an airport gate where everyone had missed their flights. The judge, Honan, Ellen Reeve, had a voice that sliced through the room like a clean edge. We weren't at trial. This was a hearing on whether to appoint Lydia as personal representative and whether the court would grant me temporary access to the property or appoint a neutral. Lydia's attorney stood, introduced himself, and called me the internet niece. I kept my face neutral. He argued that the codicil clearly reflected Ruth's final wishes and that Lydia had provided unpaid care and support. He emphasized the no contest clause. He said I was whipping up drama for my channel. When it was my turn, I stood and said, "Your Honor, the house is in the trust." The codicil tried to revoke a gift the will didn't control. The notary stamp on the codicil is from a commission that expired March 1st, which makes the notarization invalid. Even if it were valid, my grandmother's trust has a caregiver disqualification clause in Section 12C that presumes any amendment benefiting a paid caregiver during the last year of life is the product of undue influence. I offered the trust restatement with the self-proving affidavit, the recorded video from December 28, 2024, the county caregiving payment records, the rejection notice from the brokerage confirming the beneficiary change attempt failed on March 12th, and the Secretary of State record showing the notary commission dates. I added, "There's also a green binder in the house with a hard copy of these materials. I can't access it. I'm asking for a court order to retrieve it and to appoint a neutral special administrator pending resolution." The judge asked Lydia's lawyer one question. "Do you dispute that Ms. Maddox was a paid caregiver during the relevant period?" He answered that Lydia only accepted a small stipend. The judge looked at the payment logs. $22,614 is not a small stipend, she said. Then she asked, Do you dispute the notary expiration? The lawyer said, We contend substantial compliance suffices. The judge shook her head. Not for notarization, she said, not here. The judge granted my motion for temporary access and denied Lydia's appointment as personal representative, appointing a neutral special administrator instead. She authorized the immediate recording of a certification of trust and affidavit of death by the named successor trustee, me. That meant I could go to the county recorder's office with the trust certificate, my ID, and my grandmother's death certificate, and position myself to sign for the trust. It didn't inaugurate me into royalty. It opened a door that Lydia had tried to nail shut. We went to the house that afternoon with a locksmith, the special administrator, and Mr. Sanchez. The closet door creaked. The green binder was where my grandmother said it would be. Inside, a printed copy of the trust restatement, a fresh certification of trust with a sticky note that said, Sign this after, Erin, a stamped envelope addressed to Mr. Parker at the brokerage, and a copy of the 2019 TOD form with my name in my grandmother's careful block print. There was also a piece of notebook paper in my grandmother's handwriting that said, If Lydia is mad, forgive her someday. Lydia stood in the hallway with her arms crossed and tears on her face. For a second, I saw the girl who had taught me how to make a French braid, the girl who snuck me into a PG-13 when I was 12. Grief does not cancel out greed, and greed does not evaporate grief. Both were in the air like a stain you can smell. Back at court 2 weeks later, Lydia's lawyer tried to argue that the codicil, even if notarization was defective, was still valid as an attested document because it had 2 witnesses. He argued the trust clause didn't apply to the will. He argued I'd weaponized my platform. He used the word theatrical. I responded with the deed that showed the property had been transferred into the trust in 2019, which made the will's specific devise of the house redundant. I showed the certificate of trust I had recorded and the affidavit of death recorded under instrument number 2025-0731-193. I submitted an affidavit from the UPS store manager about their February refusal to notarize, and from Mr. Halverson about the March signing, where the other witness exited briefly and where Ruth sat quietly, and from the Secretary of State regarding the expired notary. I underlined the brokerage's email that the attempted TOD change had been rejected, and that the 2019 designation naming me remained in effect as of the date of death. The judge's ruling was concise. The March 3, 2025 codicil was not self-proving due to an expired notary commission and could not be admitted without testimony from the witnesses at a contested hearing. Even if valid, its revocation of the will's gift of the house was moot because title to the house resided in the trust since 2019 outside the will. The court recognized the caregiver disqualification clause as evidence of intent and a strong indicator against any late-stage change that favored Lydia. She kept her voice low, but the gavel in her words was loud. Intent controlled here, she said, by trust instrument and by deed. She ordered Lydia to turn over all keys and estate documents within 48 hours. She ordered the special administrator to coordinate with me to secure the property, and she set a separate hearing regarding allegations of misappropriation from the checking account. The fallout was messy and exact. The brokerage, upon receipt of the certificate of trust and the death certificate, released the TOD account to me within 10 business days. It wasn't drama. It was wiring instructions and a number on a screen that rose and fell with the market. The house became mine to steward under the trust, subject to final accounting, taxes, and the weight of memory. The checking account required a forensic look. Transactions in April showed a series of cash withdrawals, with Lydia's signature under her power of attorney legal at the time, but questionable. The court later surcharged her $5,800 for expenditures, not clearly for Ruth's benefit. It wasn't handcuffs, it was a spreadsheet with red lines. I decided not to throw Lydia to the internet. I kept my channel informed about the process without names, because the point of After Her Lies isn't to turn a lens on one person's worst decisions and leave it there. It's to teach you what the papers mean so you don't drown when someone turns on a hose. But let's be honest, none of this felt like a tutorial when I sat on the floor of my grandmother's bedroom and held her blue cardigan and cried into it until my face hurt. Justice is not a parade. It's a path you dig with your hands. Lydia texted me 3 days after the judge's order. She wrote, "We should talk about the house." I told her we could talk with the special administrator present. Her lawyer suggested mediation. I agreed because court is expensive, and mediation is where truth often shows its face. At mediation, we sat at a faux wood table with a woman who'd done this 1,000 times. Lydia's opening was a brittle laugh. "I did everything," she said. "She left you everything because of a piece of paper." The mediator asked us to list our non-negotiables. Mine, the house stays, the TOD money stays. I am not pursuing sanctions if she returns the jewelry and recipe cards and agrees to a no-contact clause regarding harassing comments online. Hers, she wanted $25,000 for caregiving. The mediator tilted her head. I slid the county payment logs across the table. "You were paid," I said. "You were paid 22 Susskingston 14. Lydia fell quiet. Eventually, we agreed she would receive the personal property she'd been promised in the 2019 Willa Cedar chest, her wedding china, and a $10,000 specific bequest was revived in her favor because my grandmother had put it there long before any of this storm. In return, she signed a release and agreed that she would not contest further. We recorded the agreement with the court. I moved into the house in September after repainting the living room the color of warm oatmeal and setting a plant in the window my grandmother always kept open for air. The house wasn't a trophy, it was a promise I had to keep. I hosted Thanksgiving there for the first time. My mother sat quietly in Grandma's chair, her face soft and sad in ways that don't have words. Lydia did not come, but she sent a card that said, "I hope the stuffing tastes like home." I smiled. I wanted the last sentence in our story to be softer than the pages before it, even if it couldn't be perfect. Running a channel while living through the content is a strange mirror. In one episode, I broke down the steps I took in general terms so that someone watching at 2 a.m. might find a path. Step 1. Don't assume the will is the whole map. Look for a trust. Step 2. Titles matter. What an asset is titled into determines which document controls. Step 3. Paper trails are everything. Caregiving payments, email confirmations, notary commission dates, and beneficiary designations can be decisive. Step 4. You don't have to do it alone. If you can't afford counsel, you can still file limited motions, obtain records, and buy time. Step 5. Don't turn your personal war into a public circus. Public humiliation may feel cathartic, but judges like clean facts more than viral moments. When I recorded my grandmother's voice reading "Erin Gets the House" into my laptop for the hearing, I realized she had done what people with clear heads and warm hearts do. She knew her future self might not be able to protect her past words, so she set down markers. a green binder, a clause number, a thumb drive, a letter. She didn't use legal jargon, she used love and instructions. She built a bridge out of simple sentences. And that's the part that most people underestimate when they try to bully an inheritance outcome. They believe the last paper in time wins. Sometimes it does. But law cares about more than last. It cares about capacity and procedure, and the architecture you build years before the storm. A notary's commission either is active or it is not. A deed either changed title or it did not. A trust sequence either replaced the earlier version or it didn't. When you strip away the drama, you're left with signatures and statutes. If the signatures are off and the statutes say what they say, the drama doesn't get to rewrite them. Lydia eventually sold her house and moved 2 counties over. We don't speak now, but I asked my mother to send her a photo of the dining room at Christmas, just the light on the table, nothing else. I didn't want to salt the wound. I wanted to plant a seed. Someday, maybe we'll meet in a grocery store aisle or at a graduation, and we'll exchange a nod that doesn't undo anything, but acknowledges that we remember how to be decent. As for the numbers that ran through this story, the 450,000 total, the 280,000 house, the 170,000 brokerage, the 22,614 caregiving payments, they aren't just math. They are the outlines of lives, of Sunday dinners and doctor appointments, and the kinds of errands that fill a person's last year on earth. When I mow the lawn at the house, I look at the patch where my grandmother used to plant marigolds, and I think about how many arguments can be avoided when people write down what they mean 5 years before it gets hard. July 15th, 2019, December 28th, 2024, March 3rd, 2025. These dates sit in my head like signposts. I follow them whenever I feel lost. A few months after the court finalized the distribution, I went back to the UPS store with a box of cookies and a thank you note. The manager smiled and said, "We don't usually get thanked for saying no." I told him his no had saved me tens of thousands of dollars and months of spiraling. He shrugged. "We just follow the rules." That's what a lot of heroes say when they don't want a stage. The rules, when you use them with a steady hand, can be mercy in a world that treats loud as right. In every family story I share on After Her Lies, I try to hold 2 truths. People are messy, and paperwork is precise. The messy doesn't invalidate the precise, and the precise doesn't erase the messy. If this had turned out differently, if my grandmother hadn't set that trust, if the notary commission hadn't expired, if the brokerage had accepted that change in March, maybe I'd be telling you about a settlement I made under duress to avoid a trial I couldn't afford. Maybe I'd be boxing up the house and moving into a rental and telling myself justice takes different forms. But because she set her papers in order, and because I was willing to step into a courthouse rather than a comment section, the outcome reflected the story she intended to write. I didn't win in a cinematic way. I won because the boring things mattered. If you're walking this path now, here's what I would do on day 1. Find the title to the house and see where it lives. Deed, trust, joint tenancy. Ask the financial institutions about beneficiary designations, TOD, POD, 401k, beneficiaries. Request the notary's commission information for any late-stage documents. Talk to witnesses early while their memories are fresh. Save voice messages and emails. And don't let anyone shame you for knowing the difference between grief and theft. You can mourn and notarize in the same week. You can cry and file a motion in the same afternoon. You are not less loving because you are more careful. Some evenings I sit in the doorway of the room that used to be my grandmother's and listen to the quiet. The green binder is on the top shelf of the closet, where I leave it on purpose, not because I need it, but because it reminds me of a person who loved me enough to draw a map. The house smells like coffee and Murphy oil soap, and sometimes like the burnt edges of a grilled cheese I tried to make while distracted. Life returns to rooms like this. It's not because a judge gavels it into being. It's because you carry in the plates and the laughter and the apologies, and you hang them on the nails the previous generation left for you. The last thing I want from this story is for you to think justice always looks like my win. Sometimes justice looks like a sibling who gets sober and shows up. Sometimes it looks like an aunt who admits she panicked and tried to control the uncontrollable. Sometimes it looks like a judge saying, "No further." Sometimes it looks like a bank email at 7:12 a.m. that says, "Your beneficiary designation is confirmed." In my case, justice looked like a clause, a video, a no that mattered, and a woman who spoke from a kitchen table in December and reached July with a voice that did not fade. I'm Erin, and this is After Her Lies. If you made it this far, here's the one statistic I'll say out loud. 96% of people who watch aren't subscribed. If you want more stories where families, money, and justice crash into each other, and we try to build a bridge out of the pieces, subscribe, like, and tell me in the comments what paperwork saved you or what paperwork you wish existed.